that? Welcome to season 2 of Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans. In episode 1, Kyle and I are updating the cases and topics we covered in season 1, including recent events and developments in Texas versus Rodney Reed, Damian Echols versus State of Arkansas, Oklahoma versus Richard Glossip, and State of Texas versus Henry Watkins Skinner. We'll talk about the executions of James Coddington, Benjamin Cole, and Richard Fairchild, and the status of the state's challenge to the Bureau of Prisons' interference in the execution of John Fitzgerald Hanson. Finally, we'll talk about some of the cases we'll be looking at during season 2. And good evening, Kyle. How are you? Can you hear me?
I can. I'm doing great. How are you? Happy New Year.
Very well. Happy New Year. All right. So we are going to just update some of these cases and some of the cases we've talked about since we started season 1. And first of all, do you have anything, any thoughts or comments or any reflections on season 1?
I mean, I know it was a lot of fun. I really enjoyed it, as I always. Thanks again for all the work you put in. I mean, you do so much detailed work. It's so impressive, but no, it was a lot of fun and really interesting. There's such a distinction between, I'm always amazed at the difference between kind of what is you like to say, what is in sort of the court of public opinion versus what's in the actual, courts. I mean, so many people are misinformed. I'm always amazed at just how easily people are swayed by kind of either the popular press or what goes on in social media versus what actually happens in the courtroom.
Yeah. And that is, and it's becoming more and more prevalent as so-called journalists are jumping on those propaganda bandwagons.
Exactly. I mean, we see it just in all walks of life where we don't really have journalists anymore. We just have people who jump on whatever's trendy on social media and just parrot it without any critical thinking.
Yeah. All right, so let's get started. First case that we looked at pretty much was Oklahoma versus Julius Jones. Jones's victim in that case was Paul Scott Howell. He was 45 years old. The crime took place in Edmond, in Oklahoma County, and it was right outside Paul's family home. Present at the time were his sister Megan and his 2 daughters, Rachel and Abby. They had all gone out for school supplies shopping. This was July 28th, 1999. They stopped at Brahms and they left and did not realize when they left that they were being followed by an Oldsmobile Cutlass driven by Christopher Jordan and carrying Julius Jones as passenger. When they reached the house in Edmond, Jones got out of the Olds, crossed the street, and waited for Paul to open the door of his Suburban. Then Jones shot him in the head as he stepped out of the truck. Megan grabbed the girls and they headed towards the safety of the house. Jones yelled at them to stop and fired 1 shot, then searched Paul for the keys, got into the Suburban, and as he drove out of the driveway, he ended up driving over Paul Howell's body and crushing his legs. The abandoned truck was found on around July 30th, 1999, near an auto shop owned by Kermit Lottie, who had acted as a middleman between Liddell King and Jones for a stolen truck, but had backed out when he found out there was a body attached. King identified Jones and Jordan when he was questioned, and police went to Jones's parents' home and surrounded it, but Jones was able to escape, only to be arrested days later. And Jordan was arrested on July 30th, 1999. Jones was convicted of first-degree murder, felon in possession of a firearm, and conspiracy to commit murder on March 13th, 2002. He was sentenced to death on the murder, 15 years on count 2 and 25 years on count 3, which was a conspiracy to commit murder. His conviction and sentences were affirmed on direct appeal in 2006. He applied for a writ to the U.S. Supreme Court, which was denied, making his conviction and sentence final on October 10th, 2006. Jones also pursued state and federal post-conviction, which ultimately his last state post-conviction application was denied on September 28, 2018, making him eligible for execution. He did appeal that denial to the U.S. Supreme Court, but that writ was also denied. In October of 2018, he did successfully petition for DNA testing of a red bandana that was found in his house, wrapped around a .25 caliber pistol. The results of that DNA testing, which were actually, that was what was reported on the 29th of October, 2018. Jones could not be excluded as a major DNA contributor at 7 out of 21 loci, and that makes 1 in 110 million people in the African American population. They would have to pull 110 million people of African American descent from the population to find a profile identical to those 7 loci. That's what that basically means. There were 3 or more minor contributors to the DNA found on the bandana, but again, Jones couldn't be excluded as one of those contributors. Jordan, however, was excluded as a major or minor contributor, and a presumptive test for saliva was negative, possibly due to the breakdown of saliva below the testing threshold. So in other words, the bandana found wrapped around the murder weapon in Jones's house had Jones's DNA on it. And this is something that the media consistently misrepresents. And to this day, they either ignore its existence or they misrepresent it. On September 23rd, 2021, Jones did receive an execution date of November 18th, 2021. On November 18th, 2021, Executive Order 2021-25 was signed by Governor Kevin Stitt, which commuted Jones's sentence on the recommendation of the Pardon and Parole Board from death to life in prison without the possibility of parole. So the Jones was not executed, and he's since been transferred to wherever his security classification requires him to go for life in prison without possibility of parole. Of course, in the media, in the year and change since his sentence was commuted, he's bitched and moaned and groaned about not being released from prison.
Yeah, well, I mean, in some ways, maybe just spending your entire life in prison is worse than being executed.
Well, but he thought he would be released from prison, and I think that's what he's bitter about.
Oh yeah, he thought he would, but yeah, in some ways it may have been worse for him because now he's going to have to rot in prison for the rest of his life.
Yeah.
And I mean, I know a lot of these cases, I mean, this was just so, I mean, this and the West Memphis 3, I mean, I guess Rodney Reed too, but I mean, some of the cases, the convicted know the victim, but these are just, I mean, such horrible random acts. I mean, guy's just minding his own business, taking his family out for ice cream and gets shot. And then people give attention to these thugs and act like these thugs are innocent. It's just very
Yeah.
frustrating.
Yeah. It is. And you know, we talked about the facts of the case, maybe not as in depth, because I think this is one of the episodes where we had wonderful guests on to talk about the case with
Right.
us. But you know, they've tried to point the finger at Chris Jordan as being the actual shooter. They've tried to trick Megan, Paul's sister, into changing her testimony. They've tried to convince her that you actually saw Chris Jordan, not Julius Jones. And Julius Jones has written letters to her trying to convince her to change her testimony. So all around, he's just a loathsome human being. But he got lucky. The Pardon and Parole Board was stacked with activists at the time. They recommended that he actually be granted life with the possibility of parole. But given his disciplinary history in prison, I don't think he would have even been able to get parole.
No way.
But he did get off. Now, leading up to his execution, there were a lot of protests, or the date of his planned execution, there were a lot of protests. And during one of those protests, a pastor by the name of Derek Scobie was arrested outside the governor's mansion. I believe it was a misdemeanor charge for blocking the road, and troopers had told him to get out of the road, and he refused. And so he was arrested, and there was a misdemeanor charge pending against him. But that charge was subsequently dropped on December 13th, 2022. And that's really been the only newsworthy event, aside from the family and Julius Jones's continued bitching and moaning and groaning in the propaganda press about the case. And as of January 8, 2022, the last time I checked, Julius Jones has not filed a single legal challenge to his conviction, his sentence, or the commutation that he received. His family and supporters continue their campaign in the court of public opinion to paint Jones's case as one of wrongful conviction, but they have not taken the steps required to have a court declare it as such. And so that is where Julius Jones stands. And we may revisit his case, just you and I, in a little bit more depth.
Yeah.
At another
That sounds like, again,
day.
more PR than actual anything substantive.
Yeah, it is. And it is. It's all PR. It's all in the court of public opinion.
Yeah. Well, that's the way they think. They can get enough people on social media to demand, that's what we have to stop trying cases on Twitter. It's ridiculous.
Yeah. And I think what they're doing is they're continuing to keep this court of public opinion campaign going in the hopes that an activist governor and another activist pardon and parole board will come in and actually let Julius Jones out of prison.
Yeah, for no other reason than the fact that he says he didn't do it.
But there are issues of Oklahoma law that likely would prevent that from ever happening. But we'll talk about that a little bit more too if we look at Julius Jones in depth down the road. All right, so the next case that we talked about, or the next issue we talked about, was the activist Oklahoma Pardon and Parole Board at that time. And one of the reasons that this topic came to the forefront is that on February 9th, 2021, Andrea Lynn Blankenship, age 41, Leon Pye, age 67, and Chaos Yates, age 4, were attacked and killed by a parolee named Lawrence Paul Anderson Jr., or Lawrence Paul Anderson. I'm not sure whether he's junior or not. Anyway, Anderson had a long criminal history and had been denied commutation in July of 2019. In spite of board rules requiring a 3-year wait for redocketing, Anderson submitted a new application in August 2019, was redocketed in October 2019, and went to a stage 2 hearing in January 2020. The board recommended commutation to the governor, which was approved by Governor Stitt in June of 2020, commuting Anderson's sentence on drug charges to 9 years. Anderson was released on January 16, 2021, after serving only 3 years in prison on his drug charge. And he had prior sentencing and prior disciplinary issues as well. So he should have never been in the position to be released. Less than a month later, Anderson murdered Andrea Blankenship, his uncle, Leon Pye, and Pye's granddaughter, Chaos Yates. Anderson also severely beat his aunt, Delcy Pye, who survived. But I believe she was left blind as a result of the attack by Anderson. It was this particular case, most of all, that led to a grand jury being impaneled on October 18, 2021 to review issues, including the operation of the Pardon and Parole Board. They had multiple things on their docket. They held sessions between November 2nd, 2021 and May 12th, 2022, where they took witness testimony and they reviewed documents. And that was various dates in November, December, January, February, March, April, and May. And again, they were reviewing 3 or 4 different issues. So not all of it would have been related to Lawrence Anderson. Pardon me. On January 14th, 2022, the Adam Luck, who was, I believe, the head of the head of the Pardon and Parole Board at that time, or the chairman of the Pardon and Parole Board at that time, submitted a letter of resignation to Governor Stitt. Dr. Edward Cunis, I can't pronounce this last name. Koenig?
Yeah, I'm not sure I can do any better.
It's Polish.
Yeah.
Konecki was appointed to replace Luck. And then in March of 2022, and this is ahead of the grand jury report, I might add, Kelly Doyle, another activist member of the Pardon and Parole Board, also submitted her letter of resignation. And on March 31st, Governor Stitt appointed Kathy Stocker to replace her. On May 12th, 2022, the Board of Pardon and Parole issued its report on the matters that it had reviewed or investigated. And I mean, there were a lot of really a lot of findings about the Pardon and Parole Board and the way it was operating while Luck and Doyle were members, that they lacked transparency, that in the process utilized for their commutation decisions, including that members met outside the open meeting process, that they lack sufficient objective criteria in making commutation decisions, and that lack of objectivity created public distrust in the board's decisions, that they were ignoring procedures designed as safeguards to speed up the commutation process and increase the number of commutations that were being heard and recommended. And this was done when basically the Oklahoma legislature reclassified some drug offenses and made them misdemeanors rather than felonies. And in response to that, the Pardon and Parole Board decided, well, if they're no longer felonies, then the people that are serving felony time need to be let out of prison. but that's not how it's supposed to work. And so, but that was a finding later on. Anyway, they specifically as to Anderson, they found that his application, which was filed in August of 2019, was shorter than the previous application and demonstrated no change in circumstances that would have accounted for a change in Anderson's unfavorable recommendation becoming a favorable one. The turnaround in the board's voting on Anderson's case showcased a clear lack of objective criteria and any requirement that the board use any criteria at all if they chose not to. Anderson's case also demonstrated the need for discernible criteria to be used by the board to make their commutation recommendations. It was also determined that a high-level administrative staff member identified that Anderson had been docketed in error, but a unilateral decision was made not to bring that error to the attention of the board or the governor's office, which prevented either entity from correcting the error before the case went to the governor for approval and preventing the governor from denying the recommendation. There was also no internal investigation conducted by the board to determine what happened. There were 4 other murders committed by inmates released in the commutation push in 2019 to 2020. And that since the hiring of the current executive director, so the other executive director left, the safeguards were back in place and problems that had come up during this push appeared to have been mostly resolved. And then there were multiple findings about how the board was using commutations improperly, even though they say they're rare and they say they're not a vehicle for early release. That's exactly how that particular board was using commutation. And they also recommended that board employees and board members should receive training, which is critical, on board functions via the Oklahoma Constitution, Oklahoma statutes, administrative rules, and board policies and records of training should be available to the public to document training conducted. They also found improper political pressure was put on some of the board members prior to their appointment, and decisions were being made about upcoming votes, including dismissal of the then director of the agency. So
I'm guessing they wouldn't mind if there was political pressure as long as it pointed to the innocence fraud movement. They would not object at all to that.
Well, no, as
Like
long as it was in line with the innocence fraud movement.
Yeah, they only object to political pressure if it goes one way.
Right. But I mean, they weren't out. If they were being pressured by the governor to vote a certain way and to handle things a certain way, which I think that was what Governor Stitt was pushing, because he wanted to be seen as a reformer. That's not how the Board of Pardon and Parole, they're supposed to be independent. They're not supposed to be under the governor's thumb. And that was what they were. And so one of the big things is that the grand jury questioned the authority of the legislature to retroactively change the range of punishment for any crime, because neither the legislature nor the board has authority to change the range of punishment. And the grand jury was disappointed that neither the attorney representing the board nor the attorney representing the state brought that particular fact to the grand jury's attention. They also found that the parole board is not qualified, and this is important. We have to remember this we're going to have an upcoming clemency hearing in Richard Glossip's case, I'm sure, where Don Knight is going to try and present, quote, new evidence, unquote. And this is how the grand jury found, this is what the grand jury had to say about that tactic, which is what led to Julius Jones being recommended for commutation. The parole board is not qualified to make determinations related to new evidence claims, and this section, as it relates to commutation, should be removed and never considered by the board. Issues regarding new evidence claims should be heard in a court of law. Applications are not fact-checked, nor are they checked for legitimacy of legal arguments. The 20 minutes allotted by the board for consideration of applications is not sufficient to litigate new evidence claims, and board members are not trained to determine what is and is not new evidence in the legal sense. And so that is pretty much, I mean, there were 25 different separate recommendations with some sub points. But that's basically, the Pardon and Parole Board did not come out looking very good. No criminal action was recommended at that time. Not to say that they might not impanel another grand jury and look at that a little bit more after Lawrence Anderson's criminal case makes its way through the system. But those were their recommendations. And one of their final ones, that government workers should be required to utilize government email systems when discussing government business, because apparently it was discovered that there was some email traffic on private.
There's a bunch of Hillary
email.
Clintons in Oklahoma,
Apparently.
all using their not president at gmail.com.
Yeah. So, so that's the Oklahoma Pardon and Parole Board findings.
It's amazing. I mean, just the general level of incompetence that people that work for the government. I mean, I hate to paint with a broad brush, but it's amazing. You hear these stories. It's like normal people that work for companies don't make these kinds of mistakes most of the time.
Yeah, I know. All right. So next case we have is Texas versus Rodney Reed. The victim in that case is Stacy Lee Stites. She was 19. The date of her murder was April 23rd, 1996. Contrary to what Rodney Reed's advocates want people to believe. Basically, Stacy left her apartment in Giddings, Texas at around 3 a.m. to travel to her Bastrop, Texas job, where she was due for an early morning shift in the produce department at an H-E-B grocery store. At some time during that drive, she encountered Reed, who abducted her, raped her, and murdered her. Based on a statement from a newspaper delivery person, Stacy's body was placed off the side of a road in rural Bastrop County at some time after 4:00 a.m. The red pickup truck Stacy was driving was left in a parking lot behind Bastrop High School and was noted by a police officer at around 5:23 a.m. Stacy's body was found at 3:00 in the afternoon. Reed was not immediately looked at as a suspect in spite of his history of domestic violence and prior rape allegations, including a 1995 rape on the railroad tracks near the high school parking lot. It wasn't until he attempted to abduct another 19-year-old woman in the same area that led police to compare Reed's DNA to the DNA found with Stacy's murder. In an interview on April 4th, 1997, Reed denied knowing Stacy, but he didn't know about the DNA at the time. At his trial, he claimed a secret relationship with Stacy, but presented two witnesses who were not found to be credible by the jury. He was convicted and sentenced to death. So he was convicted on May 18th, 1998, and he was sentenced to death on May 28th, 1998. His direct appeal in 2012, December 6, 2000, his conviction and sentence were affirmed. He has filed a total of 11 post-conviction writs in state court. Writs 1 through 9 have either been dismissed or denied, with some claims dismissed. He has had claims remanded to the trial court, and he's had the opportunity to have hearings on those claims, but in the end, he has not proven those claims, and relief has been denied by the trial court after those hearings. He's also pursued federal post-conviction claims in the district court, U.S. District Court. He had a petition for writ of habeas corpus and amended petition denied. and a motion for summary judgment granted by a magistrate's report and recommendation, which were adopted by the district judge, denying relief, granting the motion for summary judgment, denying a motion for additional testing and certificate of appealability, and a final judgment was entered, and that was in September of 2012. And then the Fifth Circuit affirmed that in January 10th, 2014. He received an execution date, and his execution was initially set for January 14th, 2015. He filed on the day of the hearing for his execution date. He filed a motion for Chapter 64 DNA testing. And there was actually an agreed order for limited DNA testing outside Chapter 64 entered by Reed and the state, I believe, on that date. And basically what the state agreed to test was evidence being held by the crime lab, the Department of Public Safety crime lab, and to be tested by the Department of Public Safety crime lab. The results of that testing came back in 2015 and not only confirmed all of the DNA evidence admitted at trial, but subsequently found 2 additional instances of Rodney Reed's DNA on Stacy's pants that were on her body when it was found, and on the back brace that was in her truck when it was found. So, in other words, DNA has not led to the identification of a third party or some other killer, including Jimmy Fennell. And I didn't include that on my summary because I forgot. So, in the meantime, Reed had been appealing the federal post-conviction claims at the U.S. Supreme Court, which denied a writ on November 3rd, 2014. There was a hearing held on Reed's Chapter 64 motion for DNA testing. The motion was denied, but his January 14th, 2015 execution date was withdrawn, and his execution was reset for March 5th, 2015. And an order was entered on the Chapter 64 motion. Findings of fact and conclusions of law were entered on December 12th, 2014. And basically, I know there's a lot of misrepresentation in the media about this, but Rodney Reed's conviction is 100% supported by DNA evidence linking him to Stacy Stites' body.
Yeah, this is one of the silliest
And
innocence fraud cases out there, it feels like. I don't know how anyone could doubt that Rodney Reed is guilty.
It includes multiple instances of Rodney Reed's DNA in and on Stacy's body. Not to mention that we've also found, with additional DNA testing, we found 2 additional spots linking him to the body at the side of the road and the truck via the back brace.
Well, and the fact that he was basically committed the same crime multiple times. That's how they caught him.
Yeah. Well, the first time he committed this crime, this type of crime, he didn't kill her. But
and he was
able to convince the jury. He was able to convince the jury that there was a secret relationship.
Yeah, he ran the same play in Wichita Falls, and the jury magically acquitted him. But yeah, it's like at some point, this guy isn't, like we say about the West Memphis Three, he has to be the unluckiest guy in the world because he keeps magically having unconsensual sex with women who claim that he raped them, and
right. He's having consent, and every time he gets caught, it was consensual.
Yeah.
And he was having a secret affair with Stacy, and but the 2 witnesses he presented at trial were not believable. His attorneys alleged that they spoke to multiple HEB employees who did say there was a relationship, but those people refused to testify, although they've never identified specifically who they talked to. And we'll get into that a little bit later when we talk about the writs that are pending at this time. Now, in the with the new execution date pending, Reed did file a state post-conviction writ, writ number 7, and he got a stay of execution on February 23rd, 2015. However, ultimately that writ was dismissed on May 17th, 2017, as an abuse of the writ, because what he was presenting did not meet the criteria for further development under Texas post-conviction law. He also filed 2 other writs, 8 and 9, and claims in 8 were remanded to the trial court for a hearing in 2017. But ultimately, those 2 writs relief was denied on the remanded claims, and the remaining claims were dismissed on writ 8 and writ 9. And that was the one where they claimed that Jimmy Finnell lied at trial because his friend Curtis Davis said he was out drinking the night before Stacy died. And they use that. They say, well, he came home drunk and there was a fight and he killed her and then he had to cover it up. But the holes in that story, you can drive a freaking what is the big A1? What is the great big plane, like the Air France plane that crashed?
Oh, the A380.
A380. That's it. I mean, those are big. You could drive at full wingspan and not touch the sides, because first of all, they don't have any way for Jimmy Finnell to have abandoned his truck in the parking lot of the high school and then to get back to Giddings. They've never produced a single witness who says, oh, he called me. I didn't know what was going on. I drove him back to Giddings. They've alleged that it could have been Curtis Davis. It could have been David, his friend David Hall. It could have been other officers at the Giddings Police Department. But even when they've had those officers on the stand, they have never asked them, did you do it? And they've never confronted them with having done so.
Yeah. I mean, the Reed case up to the West Memphis 3 is the most fantasy when it comes to alternative suspects.
Magical thinking.
Magical thinking where there's no evidence to point to an alternative suspect. But we feel it must be this person.
Yeah. And it's feeling and belief.
Exactly.
Not
feeling without evidence or intellect.
What is really actually is most insulting is that when you read the media articles, they claim that they've proven it. They've claimed that there's evidence. But it's basically witnesses who came forward years after the fact, who didn't say anything to officers in 1996 when Stacy was murdered, 97 when he was arrested, or 98 when he was on trial. So, and he appealed the denial of DNA testing. That judgment was affirmed on April 12th, 2017. He filed a motion for rehearing, and that was denied on October 4th, 2017. The mandate issued on October 10th, 2017. And he filed a writ to the U.S. Supreme Court, which was denied on June 25th, 2018. And the timeline for the current Supreme Court federal DNA claim is actually triggered by the state denial of DNA testing. But we'll talk about that again too later. So Reed was given another execution date on July 23rd, 2019. His execution was set for November 20th, 2019. He filed another writ, and on November 15th, 2019, that writ was remanded to address Reed's Brady false testimony and actual innocence claims, because he came forward with allegations that Fennell had made confessions to various people to having killed Stacy, and he claimed to have discovered HEB employees who knew about the affair with Stacy and for some reason thought it wasn't important enough to mention when Stacy was murdered. And I still to this day do not understand how anybody could think that your murdered coworker being engaged to a white police officer and having an affair with a black guy is not worth mentioning when she's found raped and strangled on the side of a road. And I have yet to hear a valid explanation for that. So his execution was ultimately stayed. He also had filed a 42 USC 1983 claim challenging the constitutionality of Texas DNA testing statutes, and basically claiming that he was being denied due process when he was denied access to the evidence for testing. He also had filed a writ with the United States Supreme Court when his 8 and 9 state writs were dismissed, and that writ was denied on February 24th, 2020. The district court was affirmed when they dismissed. Oh, wait, sorry. On April 21st, 2021, the district court dismissed his claim related to denial of DNA testing based on the fact that he didn't file it timely under Fifth Circuit precedent. And I've screwed up my notes here. So he had a hearing in July of 2021 at the district court in Bastrop County, and several witnesses testified for Reed and the state regarding relationship, regarding alleged confessions by Fennell, et cetera, et cetera. And on October 31st, 2021, Judge J.D. Langley, who had taken over from Judge Doug Shaver, entered his findings of fact and conclusions of law, recommending that Reed be denied relief on grounds 1, 2, and 4, which were the remanded grounds. On December 8, 2021, Reed's counsel filed a motion to supplement the record with the court reporter's audio. And basically they're arguing that they need to enable the Court of Criminal Appeals to assess witness credibility, and that audio is what they need to do that. Now, under Texas law, that's not really how it works. The Court of Criminal Appeals is not a court of they don't take evidence. They don't hear cases on their own. They review how the district courts have ruled on cases. So they don't assess credibility. They rely on the trial court to do that. So the judge of course, denied that request. They also filed a writ on December 22nd, 2021, alleging Brady violations regarding statements from HEB employees that allegedly established the existence of a relationship between Stacy and Reed. However, those statements really don't establish a relationship between Stacy and Reed. The first statement that they rely on is a statement from the manager, Ron Haas, who says he had heard rumors that there was a relationship. The second statement is from Andrew Cardenas, saying that Jose Coronado told him that Reed visited Stacy in the store. Then there's a statement from Coronado, who denies making the statement that Cardenas claimed he made, and who says, I didn't know anything about this guy or about a relationship with Stacy. And then there was another claim about a statement made to by Susan Hugan, who was one of Reed's witnesses at the hearing when she was being interviewed in June of 2021 in advance of that hearing, which was not a statement she made prior to trial that could have been disclosed for Reed's trial. And also there's a trend to make it appear to the public that the police not only have to investigate and develop evidence in their own case, but they're 100% responsible for developing evidence in the defense case. And that is simply not true. Reed had access to these HEB employees. His attorneys claim they spoke to HEB employees who confirmed a relationship, but those employees refused to testify, and they did not pursue testimony from those employees, even though they could have. They could have compelled their appearance by subpoena. They could have gotten permission to treat them as hostile witnesses and ask them leading questions. And they could have threatened them with perjury if they refused to testify consistent with prior statements. They didn't do those things. But now in media and in court of public opinion, they're claiming that multiple employees at HEB confirmed a relationship. So I don't think this writ is going to go very far. I think that when the Court of Criminal Appeals determines whether or not to grant relief on 10, they're going to also dismiss 11. Because this also could have been discovered and presented before. The U.S. Supreme Court on April 25th, 2022, granted certiorari to Rodney Reed in his challenge to the dismissal of his due process constitutional challenge on April 25th, 2022. His attorneys have also filed amended objections of fact, and my stuff's out of order here. I don't know how I did that. And they posted it on January 31st, but they didn't file it until February 11th. So again,
why do you think there was a big delay?
Court of public opinion. They're playing to the court of public opinion.
Okay, so they just let it out there so people could.
Because basically they're falsely telling the Court of Criminal Appeals in their objection to Judge Langley's findings that actual innocence has been proven when it has not.
They're just leaving it out there so people can formulate that
They're
opinion.
claiming the district court abdicated its duty by rubber stamping the state's findings, which the court knew contained factual errors. Well, you don't agree with the facts that the judge relied on, but that doesn't make them errors. They also claim that all of Reed's witnesses, despite their failure to come forward in 96, 97, or 98, were more credible than the witnesses presented by the state, not only at trial, but at the hearing. They claim that Fennell lied at the evidentiary hearing and during the investigation, and has been proven, and that's been proven even though it's just his conclusory allegations. They claim that Reed's forensic testimony was unrefuted when it was refuted by the state's experts in multiple aspects. And they claim they re-dredge up Dr. Biardo's 2012 affidavit, claiming it recants his trial testimony, which was an argument that's already been rejected by both state and federal courts. Let's see. The Intercept is the main rag that just buys the propaganda and spoon feeds it back out to the public.
I mean, the Intercept is basically like an Instagram post of, blondes talking about how great Playboy is. I mean, it's not even credible. It's like actually kind of funny.
And, you know,
Ever
I mean,
since
they
they
just,
fired all their journalists a few years ago, right?
yeah,
Now it's
right. And
just
they
like
kept,
kind
but they
of,
kept Jordan Smith,
yeah, it's
whose name is
just,
Jordan Chronic, which suggests to me
yeah,
that it's not because she has lupus.
yeah, exactly. Yeah. It's just kind of a
So she's rotted her
comedy
brain.
store. Exactly.
And then there's a Liliana Segura who is now her new partner in crime.
But they don't care about the facts. They
No,
have an agenda and they just whatever they can emotionally get their,
I think they
couple of readers
basically,
worked up about.
although I have to give them some credit, they do, they are better writers than Reed's defense attorneys.
Fair,
I'll
but
give
that's not
them
saying
that.
much. Fair enough.
I'll give them that. So on October 11th, 2022, Reed's oral argument was held in Reed's U.S. Supreme Court case, basically challenging the denial of DNA testing under due process grounds. There was an article in August by The Intercept, an article on the 23rd. And of course, according to The Intercept, Reed's counsel nailed the argument and the state just didn't. They also make some false implications. First of all, they imply that the state of Texas is inventing new barriers to prevent Reed from obtaining DNA testing, when in fact, the state's arguments dealt solely with the time for filing of Reed's 1983 claim. And what is often lost on the public because the media is not accurately reporting things is that even if the Supreme Court finds in Reed's favor, that only resurrects that due process claim. It doesn't have anything to do with the merits of his request for DNA testing under Texas law. So there's no, the federal court is not going to give him DNA testing, even if he's successful at the Supreme Court. The Supreme Court's not going to give him DNA testing. It can't. The only court that can do that is the Texas court, and that's not going to happen unless the Texas law is declared to be unconstitutional.
Right.
So,
Yeah, we don't just keep retrying cases in social media. It's like there's a
yeah,
very set process and things that must be followed for right or wrong.
yeah. And you know, they continue to give the false implication that the state bears the burden to prove Reed's guilt by offering new evidence of Reed's guilt, when in fact the burden rests entirely on Reed to prove his actual innocence. And given the DNA evidence that underlies Reed's conviction and the absence of credible evidence of a relationship, that's done. And that's part of the reason he can't get DNA evidence, is because unknown DNA on the belt, Fennell's DNA on the belt, no DNA on the belt is not going to exonerate Rodney Reed.
Right.
Under the facts of the case and the DNA evidence that already exists. Then McCrae wrote a letter to the Court of Criminal Appeals, and he's again feeding the propaganda mill by updating them about the oral arguments, and then alleging that the record returned by the district court is incomplete due to the denial of Reed's motion to supplement, and that the TCCA needs that audio to independently assess the evidence presented at the hearings, but that's not what they do. You know, they determine whether the judge, whether the judge's assessment of the evidence, and they could disagree by reading the cold record. That's certainly happened in this case once before, but that doesn't mean that that doesn't even mean they're going to grant relief. So the status right now is the Supreme Court is expected to hand down an opinion before the end of its term, which is in June, but we don't have a timeline. It may or may not be month, or it may be at the end of the term. It's unusual, I think, though, for them not to at least hand something down by the end of the term. His writs 10 and 11 are still pending a decision by the Court of Criminal Appeals. On 10, the Court of Criminal Appeals decides whether to adopt Langley's recommendation on the remanded claims or to grant Reed relief, which they potentially could do. Highly unlikely, but it could happen.
Yeah, I don't know. I worry about the public opinion on this one. I just worry about so much pressure. But I don't know. Is the Kardashian girl still into the Reed
Well,
case, or
he's
has she
not in
gotten
danger of being
distracted?
executed, so I think that she won't show her ugly face again until, well, no, I shouldn't say ugly. I'm sorry. That was bad. I shouldn't have said that.
But I don't know if she's
She
lost
won't show
interest or
her highly
not. Yeah.
Botoxed face until until he's up for execution again.
Yeah, they may have lost interest, but I feel like that's what you worry about is all these people are like, oh my gosh, I can't deal with the Twitter mob.
Well, I think the Twitter mob, they go away eventually, and they lose interest eventually, especially
Yeah,
after they're executed. But that is still, like I said, pending, and I think more likely than not, they'll adopt Judge Langley's recommendation and dismiss the remaining claims in that writ, and at the same time, they'll dismiss 11 as an abuse of the writ, because
right.
this information could have been discovered independently. It could have been discovered sooner. It could have been presented sooner.
Exactly.
So now we go with the KFC murders, Texas versus Darnell Hartsfield and Romeo Pinkerton. The murder victims in that case were killed on September 23rd, 1983. May have been September 24th, 1983. We don't really know for sure. They were Mary Tyler, 37, Opie Ann Hughes, 39, David Maxwell, 20, Joey Johnson, 20, and Monty Landers, 20. They were killed, or they were kidnapped from a Kentucky Fried Chicken in Kilgore, Rusk County, Texas on Friday, September 23rd, 1983. Opie Hughes and Joey Johnson were working their shift. Two co-workers, Kim and Ashley, were also working in the restaurant. David Maxwell, a KFC employee, and Monty Landers came in that night to give Joey Johnson a ride home. Toward the end of their shift, a customer who was in line to place an order heard a woman on the phone at the counter inform a caller that the restaurant deposit had not been made and that there was $2,000 in the register. Starr later told police that the two African-American men behind her heard that statement. She also observed a white van parked at the back of the restaurant, even though there was no parking spaces. At 11 p.m., I believe it was Mary Tyler, returned to the restaurant. Oh, no, sorry. Somehow Mary Tyler, I don't know if she was working or if she came back because the deposit hadn't been made. And my notes are not complete in that aspect. But at 11 p.m., an employee returned to the restaurant to find the back door open and blood on the floor. Police were called to the scene, and they found signs of a struggle at the counter and in the back office, and observed blood on the floor, on a box holding register receipts under the cash register, and a napkin on the floor. There were no signs of the three employees, David or Monty. So Mary must have been at work. At 10:20 a.m. on Saturday, September 24th, 1983, an oil field worker found the bodies of David, Mary, Joey, and Monty along an oil lease road. Opie's body was found about 50 yards away, and police theorized that she tried to run away when the shooting started. A woman who lived in the area reported seeing a van in her driveway on the night of September 23rd. The van left, and she reported hearing gunshots a short time after seeing the van. But hearing gunshots in that area wasn't unusual, so she didn't contact police at the time. There was another lead that came in on September 26, 1983, when a similar robbery was committed at a grocery store in Tyler, Texas. Police questioned Darnell Hartsfield and his cousin Romeo Pinkerton and two other men, but they all claimed to have been incarcerated on September 23rd, and records of the day appeared to corroborate those claims. Hartsfield also took and passed a polygraph, which eliminated him in the minds of investigators. The case went cold for 12 years until 1995, when it was presented to a grand jury based primarily on a torn fingernail found at the scene and faulty forensic theory that linked the nail to a suspect based on microscopic examination. Charges were soon dropped when DNA eliminated that suspect as the source of the fingernail. The case went cold again until 2001, when DNA testing found on blood found on the box under the register was linked to Darnell Hartsfield. Blood on a napkin found in the restaurant was soon linked to Pinkerton and was soon linked Pinkerton to the murders. In November 2005, Hartsfield and Pinkerton were each indicted on 5 counts of capital murder. A pretrial examination of Obie Hughes' clothing later revealed a third male DNA profile from a semen stain on the crotch of her pants.
Yeah,
Her husband.
That's the craziest thing about this case. There's still a third person out there that they have
We
not
believe,
found. Yeah.
Her husband, Hartsfield, and Pinkerton were all eliminated. Neither Hartsfield nor Pinkerton has ever named an accomplice, nor is the DNA profile in CODIS or Texas state databases.
Yep.
According to court records, DNA testing did reveal that the semen was deposited by a man who was predominantly of African American descent. And I still wonder if there's a possibility that the pants, there was contamination by evidence from some other case
Yeah, I guess that's possible.
on those pants in the years between 1983.
Yeah, that's a good point. I've never thought about, but yeah, that's definitely possible.
Even before 2001.
Yeah.
Because if testing was being done in 2001, I would have expected the victim's clothing to have been examined.
Yep, exactly. Yep.
And
Makes
that
sense.
would have been found if it was, if it was there. So I still, like I said, I wonder, especially the fact that the sample isn't in CODIS or the Texas state databases.
Yeah, it is crazy that somebody, commits.
Yeah.
This is the only crime this person's ever committed.
Theoretically, and I'm just speculating, but theoretically, what if they had a reference sample from somebody to evaluate, and during the processing of that evidence and the Obie Hughes evidence came into contact and contaminated, and that person was eliminated, so that sample went away. They can't, when they're evaluating, if they don't link you to a crime, they can't enter your reference sample into CODIS or the state database. So that would explain, because I would expect if there was a third male, I mean, that's how Hartsfield and Pinkerton were identified. Their DNA was in the system. That third person, if there was one, I would expect him to be in the system.
Yeah.
And contamination could be the reason that it has not identified anybody.
Right, exactly.
So Pinkerton and Hartsfield were indicted with 5 counts each of capital murder. Pinkerton was tried first and ended up, I believe, entering a guilty plea after the defense and his confessions in jail.
Yep, that's right.
Exactly. But I don't have that on my thing because
I think you're right.
I think I accidentally deleted in trying to pare things down. I did the same thing on Reed. I deleted stuff I didn't mean to delete. Pinkerton became parole eligible in April of 2014, but he was denied, and his last denial was 2019. Hartsfield was tried September 9th, 2008 through September 30th, and he was found guilty of 5 counts of capital murder on September 30th, 2008. The death penalty was waived, perhaps because Pinkerton had not gotten the death penalty. He was sentenced to life sentence on each count of capital murder, but it was under the 1983 statute, which means there was no life without parole in Texas. And so he would have been eligible for parole after serving 35 years on January 8th, 2023. Would have been his first parole eligibility. However, on May 4th, 2022, Darnell Hartsfield, age 61, died of a massive stroke in prison. He was serving his sentence at the Mark W. Michael unit in Tennessee Colony. He did have a parole hearing scheduled in January of 2023. Pinkerton remains in the Allred unit. His next parole review is scheduled for May 2024. And the third suspect, if there was one, remains unidentified. So that is KFC case. Next, we have New York versus Carolyn Warmus. This is the woman who probably was, if not the inspiration for the movie Fatal Attraction, she may have been taking a page out of that movie's book. Because if the Solomons had had a bunny, she probably would have boiled him.
She probably bought a bunny just to try to boil it.
Betty Jean Torrey Solomon, age 41, was murdered on January 15th, 1989. So yesterday was an anniversary of her murder of sorts, I guess. The murder took place in Greenburgh, New York, which is in Westchester County. It was in the Solomons' apartment or condo. In the fall of 1987, Paul Solomon began an affair with Warmus, who just started a job as a substitute teacher at Edmont School in Greenburgh, New York. Warmus became a friend of the Solomon family, spending time with them, with Solomon, his wife Betty Jean, and daughter Kristen. Which is sick in and of itself. On the afternoon of January 15th, 1989, Warmus called Solomon, who was at home with Betty Jean, and they made plans to meet at a Yonkers restaurant that evening. After the call to Solomon, Warmus's phone bill showed a call to a New Jersey gun shop, and someone using the driver's license of Elisa Katai purchased 25 caliber ammunition during that afternoon. That evening, Solomon told Betty Jean he was going bowling with colleagues and left for the Brunswick Lanes in Yonkers during the early evening. At around 7:12, an operator received a 911 call from a screaming woman whose only decipherable words were "trying to kill me." At the time the 911 call was received, Solomon was accounted for at the Brunswick Lanes in Yonkers. He left shortly afterwards and went to Treetops, the Holiday Inn hotel restaurant, where he agreed to meet with Warmus. Warmus arrived around 7:50 p.m. and claimed she was late due to traffic. The two had dinner, then went to Warmus's car for a sexual encounter. They parted company at around 10:30 p.m. When Solomon walked into the condo he shared with Betty Jean, he found her on the floor bleeding from multiple gunshot wounds. His call to 911 was lodged at 11:42 p.m. Warmus's phone records eventually led investigators to incriminating circumstantial evidence related to Betty Jean's murder, and showed that in addition to following Solomon to Puerto Rico, she attempted to interfere with his relationship with another woman by posing as a Greenburgh detective and informing the girlfriend's mother that her daughter was dating a murder suspect. They also led to a second investigator who shed light on Warmus's plan to doctor photographs to be sent to another boyfriend's wife to sabotage his marriage. Warmus was charged with second-degree murder and second-degree criminal possession of a weapon because she bought the weapon under the table from a private investigator, who, when he disclosed this to authorities, was admitting to committing a crime. because New York has very, very strict gun control and very, very strict sale of gun
Yeah.
laws.
So he has no incentive to,
Yeah.
he's definitely knows what the risk he's taking.
Yeah. So Warmus was initially tried in 1991, but that trial ended in a mistrial in spite of the circumstantial evidence that jury heard. Jurors were 8-4 for conviction, however, so only 4 were fooled. Subsequently, Warmus was indicted for forgery and tampering with evidence because at the first trial, a forged MCI phone bill was presented by the defense. She pled guilty to those charges, even though to this day she denies ever doing it. Her second trial was in 1992, and there was actually new evidence uncovered between the first and second trial related to Warmus's purchase of a pair of black gloves like one found on the Solomon apartment or the Solomon condo. And that supplemented the prior evidence, including Warmus's purchase of a pistol and silencer, purchase of ammunition with stolen ID, and her obsession with Paul Solomon. She was found guilty on May 27, 1992 of second-degree murder and second-degree criminal possession of a weapon. She was sentenced in 1992 to 25 years to life on the second-degree murder and 5 to 15 on the second-degree criminal possession. Her direct appeal was denied. She made multiple other legal claims, legal challenges to obtain free trial transcripts, a legal malpractice claim against one of her attorneys, and alleged sexual assault claims against prison officials. I think she had personal injury claims against prison officials as well. She failed to establish her ineffective assistance claims on state post-conviction. She filed a 440 motion, which was denied, which alleged new evidence. And on June 17, 2019, she was granted parole based on health considerations. She apparently had a brain tumor and had suffered some disability and issues with medical treatment. And so I believe the prison felt it was in their best interest to release her on lifetime parole. In May of 2021, she and the DA agreed to testing after opposing Warmus's prior tests requests. The items to be tested were glove found in the apartment, stains from Solomon's gym bag, and semen from Betty Jean's autopsy. Now, as of January 8th, 2023, I found no indication that any agreed DNA testing results have been filed. Warmus has filed no court actions to challenge her conviction or sentence based on the results of that testing. And she's still participating in public speaking engagements, putting her side of the story out. That suggests that the DNA testing results were probably not favorable or were inconclusive. And so that is the end of that, probably. Although she will continue to claim that she's innocent. All right, next we have Melissa Lucio. And because at the time I'm going to try to I think I'm going to try to speed us up a little bit because it's 7:15 now. And we got a little bit of a late start recording, but I don't want to have a late finish. Lucio's victim was her 2-year, 5-month-old daughter, Mariah Alvarez, who died on February 17th, 2007. This crime took place in Harlingen, Texas, in Cameron County. Mariah was born on September 6, 2004 to Lucio and Robert or Roberto Alvarez. She was the 7th child of Lucio and Alvarez and Lucio's 12th child. Lucio and Alvarez had drug history. Mariah was apparently born addicted to drugs. So Mariah's birth triggered a CPS intervention, and Mariah, her Alvarez siblings, and her minor Lucio siblings were all removed from the household due to evidence of severe neglect. Lucio's history with CPS went back to 12/21/1995 with its first investigation of abuse of another child. And I'm just going to put this out there. You don't have CPS involved in your life in 1995, 96, 98, 2000, 2001, 2002, 2003, and then removing all your minor children in 2004 if there's no history of your violence toward those children.
Yeah,
Which
exactly.
is one of the claims
Yep.
made frequently, is that these hundreds of pages of CPS records, and there's no proof of any violence by Lucio toward her children, which is absolutely
Yeah.
false,
No,
because there
exactly.
are reports of documenting Lucio's violence toward a couple of her sons, other daughters. One of her daughters is on TikTok talking about the horror that was Melissa Lucio as a mother, especially when she was on drugs. The claim made by Lucio and her family is that Mariah fell down a steep staircase at their old apartment in Harlingen on February 15th, 2007.
I mean, at some point, yeah, like you said, there's just some point, so many calls. You can't have that many calls with, there's enough smoke. There has to be a little bit of fire.
And look at it. You got to look at this too. They were removed in September of 2004, and they weren't returned until November of 2006.
Right.
So, I mean, CPS doesn't do that for no freaking reason. Lucio and her family's statements regarding the fall are confusing and contradictory. Different people were there. Different people saw different things. I think some of them have Mariah falling from the bottom of the stairs, just a short distance, and some have her falling all the way from the top. And what's most troubling to me is that Lucio, even though she says Mariah was lethargic, vomiting, refusing to eat, and having trouble breathing immediately after the fall, she never sought medical care from Mariah. And she later admitted that part of that was because she knew Mariah had bruises and that she would be blamed. At around 7 p.m. on February 17, 2007, paramedics were summoned to Lucio's new apartment, where they found Mariah lying alone in the middle of the floor, unresponsive, not breathing, and with no heartbeat. Lucio's observed lack of concern for Mariah made an impression on the EMTs. At the hospital where Mariah was pronounced dead, the ER physician stated that her injuries were the absolute worst case of abuse he'd seen in his 30 years of practice. Dr. Norma Farley conducted Mariah's autopsy on February 19, 2007. She attributed Mariah's death to blunt force head trauma and opined that the injury would have caused immediate distress to Mariah, making it unlikely the injury could have been sustained more than 24 hours before her death. In addition to the array of external bruising on Mariah's body, Dr. Farley documented internal bruising on Mariah's spine, kidneys, and lung. Mariah also had a bite mark that Lucio admitted to inflicting. Lucio was charged with capital murder of a child under 6. The defense at the trial was that Mariah died from a fall, that Lucio did not cause fatal injuries, that her statement was not true, and that she unsuccessfully tried to have an expert psychologist and social worker testify regarding false confessions. So a lot of the issues that were raised and expanded on in the lead up to her execution date had been raised and rejected by a jury at trial.
But you just keep repeating them. You keep repeating them to get the public opinion behind you. Doesn't matter what the trials say. It's all the people that feel like just the court should do nothing but just retest all the DNA evidence for whoever wants it, just to make them all satisfy all the true
Yeah.
crime social media people.
And in this case, it really is horrible because, she could have had expert doctors look at
Yep.
Mariah's records
And
come up with the same alternative theories about cause of death that the experts came up with in 2021 or 2022. She was sentenced to death on July 10th, 2008. Her direct appeal was affirmed. Her conviction and sentence were affirmed on September 14th, 2011. The U.S. Supreme Court denied writ on June 4th, 2012. She filed multiple state and federal post-conviction writs. Her state writs were denied in 2009, 2013. She filed federal habeas claims, which were denied at the district court level in 2016. The Fifth Circuit panel initially reversed and remanded her case, granting partial relief on her complete defense claims in 2019, but en banc review of that decision, or of the case by the Fifth Circuit, resulted in reversal of that decision and affirming the district court's denial of relief in 2021. She also went to the U.S. Supreme Court, which denied her writ on October 18th, 2021. Her execution was set on January 18th, 2022 for April 27th. And then there's a flurry of activity in the court records and in the district court records at the Court of Criminal Appeals. I'm just going to kind of summarize. She filed seeking to disqualify the DA and the judge because her former defense counsel had taken a position with the DA's office, and his wife, who had served as his paralegal, took a position as a court administrator for the judge in Cameron County. She filed a motion to reconsider the state's motion to set her execution date, and I believe that was on the basis of this new evidence that she claimed to have, which was basically just supplementing her theories at trial, that Mariah's cause of death was a fall, that Farley's opinion wasn't reliable, that that Lucio's statement was false, that her confession was false, and that everything, everybody was wrong but Melissa Lucio. And everything Melissa Lucio did was because she was abused sexually and physically by an array of boyfriends of her mother, boyfriends of hers, husbands, Alvarez, the whole 9 yards.
Always an excuse to do anything you want.
And one of the most ridiculous claims is that she claims that at the age of 16, her sister-in-law made her use cocaine.
Right.
And
put
that's
a gun
where
to her
drug
head, I'm
problem
sure.
started. Yep. She supplemented the motions to disqualify the judge. She supplemented the motions to reconsider the execution date. And it may have also been because she was trying to recuse the judge and the DA. She filed a motion for a writ of mandamus on the motion to disqualify the judge and DA at the Court of Criminal Appeals. That was conditionally granted, and the court was given a period of time to decide on the motion to disqualify. She also filed a writ of mandamus, although I'm not sure what that was about, and a motion for stay of execution, which were ultimately denied. She also attempted to recall the mandate in her Fifth Circuit case, which was denied. Her fifth writ alleged that Farley and the trooper, or the DPS trooper, Texas Ranger Escalon, gave false testimony at the trial, that she had new scientific evidence regarding the allegation about bite marks on Mariah, that there was new evidence regarding confirmation bias of the police against her, that she had new scientific evidence of a false confession, new scientific evidence about the Rangers' claim that he knew Lucio was lying based on her body language, that she had new evidence that no murder occurred. She had new ineffective assistance of counsel claims related to suppression of evidence by the state, her a violation of her Sixth Amendment rights in her pretrial interrogation, which I think dealt with her guilty plea to a DWI, and juror misconduct claims, gender bias claims, and actual innocence of the death penalty based on the false testimony claims. She also filed a motion for stay of execution. This was all on April 18th, 2022. On April 25th, 2022, her mandamus relief was conditionally granted, and the writ will issue only in event the respondent judge fails to comply with this opinion within 3 days of the date, and the motion to stay execution was denied. Her motion for her second mandamus, unsure what that was about, and stay of execution were also denied. But her fifth writ, the motion for stay of execution, was granted, and claims related to false testimony, new scientific evidence, actual innocence, and Brady violations were remanded to the district court. She also, again, supplemented her motion to withdraw the execution date, and filed motions for attorneys to appear pro hoc vice, and filed a motion for a successive writ at the Fifth Circuit Court of Appeal, which was actually dismissed without prejudice on April 26, 2022, because her execution had been stayed and her state writ had been remanded. And interestingly enough, her attorneys were filing at the district court, at the Court of Criminal Appeals, and at the Fifth Circuit, all at the same times. I mean, there was just like a flurry of filings on Lucio's behalf, in addition to the Court of Public Opinion.
Yeah, that makes it.
So on remand, she filed a supplemental motion to disqualify the judge. Her motion to recuse was assigned on April 28, 2022 to Judge Mario E. Ramirez Jr., and he was with the 332nd District Court in Hidalgo County. The state filed a response to the motion to disqualify on June 13th, 2022. Lucio replied to that on the 21st of June. There may have been a hearing, but I'm not sure of the date, and there isn't a hearing specifically listed on the docket, so I'm not going to guess about what date it might have been. But a post-hearing submission was made on behalf of Lucio on June 24th, 2022. The state filed a motion for entry of written order, on July 28th, 2022. And that may be that the court denied the motion to recuse on the record at the hearing. And then the state wanted a written order. And that was entered on September 28, 2022. The state also responded to her first subsequent application, the remanded claims, on August 12th, 2022. The mandamus writ 3 was supplemented at the Court of Criminal Appeal, which found on October 13th, 2022, that no mandate would issue because the request to recuse the judge had been denied. I don't know whether she dropped the request to recuse the DA or not. I think the problem with her attempt to recuse the DA is that the attorney took that job in 2009. So raising the issue in 2022 was a little late. It should have been raised in 2009. Or it may have been raised in 2009 in one of her other writs. And I don't know, because those aren't Texas orders are on writs
Just
are
a lot and confusing.
bad. Well, they're bad because a lot of times they just say relief denied or dismissed.
They don't really give you any explanation.
And they don't really tell you what the specific claims were, or when it's a subsequent writ. And while their system is generally pretty good about pleadings like that being available, not always. So on December 20th, 2022, there were agreed findings of fact and conclusions of law entered by the court. However, I don't know what those were because they haven't shown up on the internet and they're not on the Cameron County website. They should be, but they're not, because Odyssey, they have that capability. And the supplemental record has not been returned to the Court of Criminal Appeal yet. There was also a joint advisory and notice of filing an exhibit filed by Lucio and the DA. But the next step is going to be for the Court of Criminal Appeals to review whatever those findings were and to decide whether to grant relief or deny relief or dismiss. All right, so that is, we have the post-Alfred DNA testing for the West Memphis 3. And I'm going to kind of skip on this one because the only significant development has been that Echols has filed his appellate brief at the Arkansas Supreme Court, challenging the denial of the trial court in Crittenden County of denying him access to evidence for DNA testing. And I'm just going to leave it at that.
Him. I feel like you should start referring to him as like Gandalf, the child murderer, or something with his weird look. I mean, seriously.
You know what? There was, in the lead up to Scott Eisenberg's execution in Oklahoma, he had a spiritual advisor by the name of Hood who went to Oklahoma from, I think, Arkansas. And there was a picture of him. And I thought, oh, motherfucker, Damian Echols is now going to get involved in death penalty cases in Oklahoma as a spiritual advisor. Because I hadn't seen the guy's name and he looked like Echols. You know, he had the goofy pants and the long black, long sleeves, which with Echols, I swear to God, I think Echols is wearing that shit even in the summer to hide track marks.
I know. It's like he plays into every stereotype about nerds, and like it's just like I don't know, I can't even describe him. He's so silly.
So I think I'm going to forego any discussion of the West Memphis 3 post-Alfred DNA testing requests until that process has worked itself out through the Arkansas Supreme Court. Although, not surprisingly, Mara Leverett is misrepresenting things.
She's telling us the earth is flat.
Well, she's telling us that DNA linked Terry Hobbs.
Yeah, she's got more she's like the QAnon earth is flat queen.
Yeah. And from what I understand, her brain is definitely been rotted by pot. Okay.
Yeah,
and
she's
she
one
probably
of those people
drank gin.
Like, she's probably telling us that lizard people killed the boys,
which is the
lizard
worst
people and a flat earth spaceship, and
which is the worst thing you can do for your brain is drink gin.
Yeah, exactly.
Okay, so we've got Oklahoma versus Richard Glossip. His victim was Barry Allen Van Treese, who was 54 at the time. On January 7th, 1997, the crime took place at the Best Budget Inn at 301 South Council Road, Oklahoma City, Oklahoma, which is in Oklahoma County. Glossip was hired in 1995 to manage the Best Budget Inn in Oklahoma City. Money collected at the motel was not deposited in a bank account, but was held in Glossip's apartment and given to Barry Vantrease when he came in person, which was less frequently during the last 6 months of 1996. Justin Sneed, also known as Justin Taylor, arrived at the motel in Oklahoma City with a roofing crew that included his brother from Texas. He and his brother quit the roofing jobs and stayed on at the motel after becoming friends with Glossip. When his brother was taken back to Texas to serve a jail sentence, Sneed remained. He earned no salary but had a free room at the motel and served as a maintenance man. He was an admitted drug user and had been accused of breaking into cars and stealing from guest rooms to support his habit. On January 6, 1997, Barry arrived at the Oklahoma City property between 5:30 and 6. He took care of payroll, checked the paperwork maintained by Glossip, and picked up money referred to as receipts that had been collected since his last visit. He left for Tulsa about 7:50 p.m., according to Glossip, taking the key to room 102 with him. Trial testimony established that he'd issued an ultimatum to Glossip to produce missing business records and receipts collected during the past weekend, and that Barry had threatened to contact police due to his belief that Glossip had embezzled about $6,000 from the business. Additional testimony established that Glossip intended to do a survey of each and every room at the Oklahoma City motel on January 7, 1997. Barry arrived in Tulsa about 11 p.m., between 11 p.m. and midnight on January 6th to 7th, where he checked the Tulsa property for off-the-books tenants, issued payroll, and collected business records for the property. The Tulsa receipts were actually deposited into a bank. Barry left the Tulsa motel after about 45 minutes, putting him back in Oklahoma City property sometime around 2 a.m. At around 4:15 or 4:30 a.m., John Beavers, a tenant, heard glass breaking around room 102 and observed a broken window and glass on the sidewalk. Sneed later testified that the window was broken during his attack on Barry. During the early morning hours, Sneed woke Glossip and Deanna Wood and reported to Glossip that he'd killed Barry. Glossip lied to Deanna and told her that Sneed told him 2 drunk cowboys had broken the window in room 102. Glossip also gave inconsistent statements about the cowboys. He claimed that Sneed rented the room to them. He claimed that Barry rented the room to them, and that the window was broken while the cowboys were fighting outside the room. Later that morning, Glossip helped Sneed place a piece of plexiglass on the outside of the window and a shower curtain over the broken window inside the room. So on at least one occasion, Glossip was inside room 102 with Barry's dead body. In spite of knowing Barry was dead, Glossip told multiple people that he'd seen Barry early that morning and that he was fine. He repeated a lie about Barry buying supplies for room renovations to several people also that morning. At around 3 p.m., Barry's car was found at the Weoki Credit Union, and Billy Hooper, a desk clerk, was summoned to identify it. She then paged Glossip to get him to come back to the hotel because Glossip and his girlfriend Deanna were shopping at the Walmart. Glossip continued to lie to people about Barry's whereabouts at a time when he knew that Sneed had killed Barry and after Barry's car had been found. He accompanied Deanna and Cliff Everhart on a search of dumpsters and fields on the properties around the motel. At around 4:30 p.m., when Officer Tim Brown joined the search for Barry, Glossip told Brown several different stories, including that he'd seen Barry that morning. Glossip also failed to mention Sneed's early morning confession and continued trying to steer people away from room 102. Between 10 p.m. and 10:30, Brown and Everhart, after comparing notes on Glossip's various statements, decided to check room 102 and found Barry's body. They found Barry lying face down, covered by the bedspread and sheet from the bed, which had been stripped. They found a shower duct taped to the inside of the window and plexiglass on the outside with caulking to seal the gaps. They also found glass stacked on a chair inside the door and a roll of duct tape. A pocket knife covered with blood was found under Barry's body. Glossop was contained and continued trying to cover up the murder and Sneed's involvement. The main way he did that is he told police the guy's name was Justin Taylor. He never mentioned the name Justin Sneed. He denied making the statements reported by Brown and Everhart. He claimed that things were getting confused. Even when detectives told him that he knew more than he was telling, he lied and denied any knowledge. Due to lack of probable cause, police were forced to release him on January 8th, 1997. Police had been keeping tabs on Glossop since his release, and on the 9th of January, he began selling his possessions, including furniture, a TV, and vending machines, and telling people he was moving on. He also visited an attorney, and he was arrested leaving that attorney's office to be questioned again by detectives. The attorney, David McKenzie, tried to help Glossop by informing detectives that he wasn't going to speak to them, but Glossop ignored McKenzie's advice and waived his right to counsel. Glossop finally reported Sneed's confession to detectives and tried to justify and or deny his false statements on January 7th and January 8th, 1997. At the time of his arrest, police seized $1,757 in cash from Glossop. After leaving the motel, Sneed went back to work with his old roofing crew. When his boss learned that Sneed was wanted for questioning about a murder by police, he contacted them, and Sneed was arrested on January 14th, 1997. And for those of you, I would suggest, if you've bought into the claim that detectives led Sneed to name Glossop as the mastermind, go read Sneed's actual statement from page 1 to the end.
Right.
And you
There's
will
always such a
find,
difference. There's always such a difference between what the actual, like, trial transcripts say versus what the popular press says.
And if you read Sneed's statements, you will find that when the detectives mentioned Glossop's name, they were not telling Sneed what to say about Glossop in any way, shape, or form. And everything that Sneed said about Glossop was basically volunteered from open-ended questions.
Exactly.
He was not led to implicate Glossop. Glossop was initially arrested and charged with accessory after the fact. But again, detectives from the beginning knew Glossop knew more and had more involvement than he was admitting. And I mean, there's no doubt about it. And again, Glossop was in custody and had been interviewed twice before Sneed was ever talked to.
Well, and again, it's like we always say, that people, changing your story, and just, there's a way that innocent people react and there's a way that guilty people act. And Glossop acted like he was guilty because everything changes. His story constantly changes. Yeah.
So, and that is, it continues to change and evolve to this day.
Yeah. And even, you're right. Today, even as he's trying to promote his innocence all these years later, he still just is making up new ways. Like, oh, I was, whatever. He just keeps making up stuff. It doesn't make any sense. So
Glossop was tried and convicted on July 31st, 1998, and he was sentenced to death. While his case was on direct appeal, there was destruction of a box of evidence that contained some financial records, the shower curtain, the duct tape, and some of the physical evidence. It was a single box. For some reason, it was transferred from the DA's office back to the police department with a note that said appeals exhausted and an order for destruction. While Glossop's advocates claim this was the district attorney's office, they haven't proven it. They haven't identified who at the district attorney's office ordered it destroyed, or that anybody at the district attorney's office actually did order it destroyed. And on November 10th, 1999, the box was marked for destruction and likely actually destroyed. Again, they claim, they make kind of inconsistent claims. They claim that the evidence was vital to Glossop's defense, and yet they claim to have disproven the state's case without any of that evidence. So it doesn't make a lot of sense. Plus, this was known about prior to Glossop's second trial. It was the topic of a hearing prior to the second trial. So while they portray it as a new thing, something they just discovered, it's not new evidence. And that's the key with, I would say, probably 98% of Glossop's claims over the years. None of it's new. It's never been new because it's been known about in one way or another, even prior to the trial. So he was his conviction was reversed on July 17th, 2001, and he was remanded back to the district court for a new trial. There had been a hearing held in 2001, and the judge who held that hearing entered findings of fact and conclusions of law, which were the basis of the reverse and remand. And basically the reverse and remand was because of ineffective assistance of trial counsel at that first trial. His second trial was held on May 13th, 2004 to June 1st, 2004, and he was found guilty of first-degree malice murder. He was sentenced to death on June 3rd. His direct appeal was decided on April 13th, 2007, and his conviction and sentence were affirmed, and that became final on January 28th, 2008, when the U.S. Supreme Court denied his writ of certiorari. He had several state and federal post-conviction claims. His last claim to be decided was in 2015, prior to our earlier review of the case, was in 2015, and that was denied on September 28, 2015. He has been denied review by the U.S. Supreme Court on his federal habeas claims. That was in 2014. His execution date was set on January 29, 2015, but that didn't go forward. It was reset to September 30th, 2015, but that didn't go forward because there was a mix-up in the drugs provided for executions to the state of Oklahoma, and the wrong drug was used in the execution of Charles Warner. So the state of Oklahoma agreed not to request any execution dates until its protocol had been reworked or amended. He also filed a writ in 2015 with the U.S. Supreme Court, which was denied on September 30th, 2015, and that was of his unsuccessful state post-conviction claim. Of course, as we've discussed with Oklahoma executions, the protocol was amended. Then there was a federal challenge under Eighth Amendment grounds to the use of midazolam. And on June 6, 2022, the judge found that the plaintiffs, Glossip et al., had fallen well short of clearing the bar set by the Supreme Court. Consequently, their Eighth Amendment claims do not stand in the way of Oklahoma's protocol. And that's paraphrased. His execution was set for September 22nd, 2022. Of course, what did Glossip do? Or what did his attorneys do? They filed additional state post-conviction claims.
It clogged the court.
Based on a report.
Glossop's clogged the court like nobody else.
A non-independent attorney or law firm who opposes the death penalty and who is an instrument of the Innocence Project, who basically re-examined the case at the behest of Oklahoma legislatures who claim to be in support of the death penalty, but then use every propaganda trick in the book to challenge Glossop's death sentence. They are not attorneys. They have no idea what they're talking about. And frankly, I don't think they bother to read any court opinions, and they certainly, if they have read them, they frankly just don't understand them.
Right. They probably don't even know which state he's in.
Reed Smith has, they did a reexamination, which really amounted to basically going and talking to everybody Don Knight talked to in 2015 and people who had been talking to Don Knight since 2015. And I think that what they did was they knew Don Knight could not use this stuff unless it was made to look, quote, new. So they gave it like a new car smell
Right. Yeah.
for
They
Don
just
Knight
put
to
lipstick
rely
on a
on their
pig.
report as his evidence, even though every bit of information, every witness was given to them by Don Knight, because they refer to Don Knight's affidavits in their report. And it's all BS. It's all stuff that has been rejected in 2015. It's stuff that doesn't prove Glossop's innocence. It's stuff that is immaterial or irrelevant to the case. In some cases, I don't know that Reed Smith even knew that Glossop was tried a second time, because some of their findings are based on the first trial, not the second. It's just crazy. And then they filed these supplemental reports, which basically are nothing more than speculative allegations regarding Snead and Snead's testimony at the trial, and allegations that Snead wanted to recant his testimony. Glossop received on August 16, 2022, he received a 60-day stay of execution, resetting his execution date for 12/8/2022. Apparently, Governor Stitt is being, how can I put this? Is being lobbied to prevent Glossop from going on death watch, because under the protocol, you're supposed to start death watch 35 days before your execution date. So on August 16th, when he would have probably been close to death watch for his September 22nd date, Stitt grants an executive 60-day extension or 60-day stay to give the Court of Criminal Appeals time to address a pending legal proceeding, because he only had one writ or post-conviction claim application filed at that time. Reed Smith supplemented their report again on the 20th of August with some more speculative allegations about Snead's testimony, claiming he wanted to recant his testimony, and claiming Brady violations occurred. And then, of course, an Intercept article continues the one-sided narrative portraying the state's case is refuted by clear and convincing evidence, and ignoring the countless prior legal opinions that refute their opinions regarding Glossop's alleged innocence. Reed Smith filed another supplemental report on September 16th, and then lo and behold, on September 22nd, Don Knight files another successive application at the Court of Criminal Appeals, raising all of the speculative allegations about Snead's testimony, a desire to recant, and alleging violation of trial sequestration orders by the DA to alter Snead's testimony. Reed Smith bolstered this BS with a 4th supplemental report to get an attorney to talk about how badly the DA violated every ethical rule and law there is, in his opinion, to craft Snead's testimony at trial, which is all speculation. On September, on October 19th, 2022, the 10th Circuit Court of Appeal affirmed the district court's dismissal of the 8th Amendment challenges to the use of midazolam in the lethal injection procedure. Glossop's deadline to seek review at the U.S. Supreme Court was January 9th, 2023. Then on November 2nd, 2022, Stitt granted a second 60-day stay of execution effective November 21st, to permit the Court of Criminal Appeals to address pending legal proceedings, the two pending applications. And he reset Glossop's execution for February 16th, 2023. On November 10th, the Court of Criminal Appeals denied or dismissed Glossop's first post-conviction successive application, basically finding that Glossop's factual innocence claims were not supported by clear and convincing evidence, that Glossop must come forth with more than what would merely tend to discredit or impeach a witness without proving the probability of the outcome of the trial would be different. He claimed they found that the evidence is weighed against the evidence as a whole in a light most favorable to the state, which is certainly definitely not what Glossop's attorneys or what these legislatures are doing. They're basically looking at this, quote, new evidence in a vacuum.
Yeah, that's
and saying the state's
that's what's
evidence
so
is gone.
yeah, they always look at these things just exactly
In a vacuum, and they don't think about holistically how all these things fit together for a single narrative.
So
Thing.
as to Glossop's factual innocence claims, and what Glossop is trying to do is relitigate previously unsuccessful claims and get a different outcome. And
Right.
that's not what post-conviction litigation is about.
It's not to re-adjudicate the same trial.
So, or it's not to retry his case for certain. The factual innocence claims, the Court of Criminal Appeals found that Glossop's affidavits do not provide clear and convincing evidence that that Glossop would like the court to believe. There's no evidence Snead ever sought to recant his testimony in any meaningful way. Glossop was raising a theory of defense that has been his claim from the beginning. Evidence provided by Snead was sufficiently corroborated by compelling evidence, including Glossop's web of deceit and deception while authorities were trying to find buried Van Treese. They also held that Glossop's guilt was proven beyond a reasonable doubt before a jury of his peers, and nothing in his current application caused the court to contradict the jury verdict. Finally, they found that Glossop's application failed to meet the burden of showing clear and convincing evidence that he is factually innocent, and that proposition was denied. As to Glossop's remaining issues, they found that they could have been raised earlier with due diligence or were not raised within 60 days of discovery. They found no miscarriage of justice. They found the destruction of evidence was known before the second trial, that his ineffective assistance of counsel claims were waived, that his due process claims were known and waived, and that his intellectual disability claims were not supported by clear and convincing evidence and could have been discovered with due diligence and were therefore waived. They also found that none of Glossop's claimed errors resulted in a miscarriage of justice. Concluding they denied his application, they denied his request for an evidentiary hearing and discovery, and they issued their mandate. So his first successive application was denied on November 10th, 2022. Of course, Don Knight, playing to the court of public opinion, he ignores the findings in that opinion, in the OCCA's opinion, and expresses his disbelief that the application failed and says, all we want is a hearing. If we show all this at a hearing, Glossop would not be convicted, blah, 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 blah. Whine, 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 whine. If I ever meet the man in person, I'm going to say, do you want some cheese with your wine? Okay. Anyway, sorry. Just amuse myself sometimes.
That was a good one.
On November 17th, 2022, the Court of Criminal Appeals likewise denied Glossop's second successive application. And basically, they found that similar claims were raised on direct appeal and in Glossop's initial post-conviction application. which they had found were barred by res judicata. As to Proposition 1, they found that the claim that the state withheld material evidence is procedurally barred and is based on speculation that Snead lied, that Glossop had presented no evidence that Snead had a desire to recant or change his testimony, that Snead's hesitance to testify was known prior to the second trial, that Glossop's attorney, Birch, gave Snead case law telling him that the state could not revoke his plea if he refused to testify, and that Birch's actions towards Snead were the subject of a court hearing on November 3rd, 2003, which led to Birch's removal as Glossop's lead attorney, which now Don Knight and Reed Smith are spinning as, well, Birch didn't really do anything wrong, whatever.
Don Knight just seems insufferable.
Yeah, he's insufferable. And I'm thinking he lives in Colorado. He's taken advantage of recreational marijuana a little bit too much, because he looks more and more disheveled as this case goes on.
Yeah. He probably knows he bit off more than he can chew.
They also found that, all of the issues being raised could have been presented earlier, and the information presented did not qualify as Brady evidence, that it wasn't new, that it could have and should have been raised on direct appeal, so it was waived, that it wasn't material and would not have changed the outcome of Glossop's trial, that the jury knew about Snead's deal, that he was the actual killer, and that he was benefiting from testifying. All these reasons, they're like, he's on death row because of the testimony of Snead. But that's not really true. Snead's testimony was a part, but Snead's testimony was corroborated by Glossop's own lies and attempts to cover up the murder. And that, more than anything else, is what led the jury to convict him. Prosecutors told the court they talked to Snead about other testimony, so it isn't new evidence and it could have been raised earlier and is thereby waived. The claims raised in Propositions 2, 3, and 4, Glossop's allegation that the rule of sequestration was violated is not persuasive, as the statute does not prevent either side from discussing testimony with their witnesses during a trial. Rule of sequestration is, if I'm going to testify, I cannot sit in the courtroom and observe the trial and the testimony of other witnesses until after I've given my testimony, and after it's determined that I'm not going to be recalled. So that's all the rule of sequestration means. It doesn't mean that attorneys can't talk to their own witnesses about, like, for example, a defense attorney can talk to a defendant about the testimony of state witnesses that look really bad for that defendant.
Exactly.
And if that were really, the defendant can't be sequestered. The defendant can be sent out of the trial. It only applies to witnesses. And again, it doesn't mean that the district attorney cannot talk to her witness about his testimony. And they haven't proven, it's speculation that she was even trying to tailor Snead's testimony, because really it's just they're just speculating. They found that the argument that the prosecutor elicited false testimony from Snead was based on unsubstantiated conversations, which is a false premise. That Glossop's claims were based purely on speculation, that the allegation that the memo could have impeached Snead lacks merit because Snead was sufficiently impeached at trial. They're talking about a memo written by, I believe, the district attorney, or a memo written by Snead's counsel. I don't remember which memo they're talking. They brought in so many extraneous, irrelevant documents. It was not even funny. But I think they're trying to overwhelm the courts with paper.
Glossop clogs the courts like nobody else. He set a whole new precedent for clogging the courts.
Yeah.
And just filing random crap.
And they found that Glossop's cumulative error claim was baseless when the court failed to sustain any alleged error, and that none of his claims demonstrate a miscarriage of justice or constitute a substantial violation of constitutional or statutory right. Again, they denied his application, they denied his request for an evidentiary hearing and discovery, and they issued their mandate immediately. So that was on November 17th, 2022. Of course, again, Knight playing to court of public opinion, says he expresses disbelief that the claims have yet again failed. And the only other explanation I can come up with is that he doesn't read the opinions or just doesn't understand them. Then Kevin McDougal,
I just don't think he
representative in
cares.
the,
I think he reads them. I just think he just doesn't care. He just knows the average person and the average politician is an idiot
yeah.
and just repeats the same crap, knowing that they'll buy it hook, line, and sinker.
And then Kevin McDougal, a state house representative, on November 30th, penned an editorial column in the Oklahoman. And again, he demonstrates that he didn't read or understand the opinions, or he's so invested in the propaganda campaign that he just ignores the mountain of evidence proving Glossop's guilt and continues to push the one-sided narrative that Glossop's guilt is in question, in spite of the court opinions that have soundly refuted that propaganda campaign over the years. Glossop's attorneys filed a sealed request for budget approval at federal court. They wanted to get a budget for their efforts during clemency and post-conviction litigation leading up to the death penalty or the execution, to try and stop the execution. That was signed on November 30th, 2022. Basically, without going into any details, they found some of the requests to be excessive. The judge approved time for attorney assistance on executive clemency proceedings, but not expert appearance at those proceedings, because he didn't find that experts were necessary. He approved time to submit a certiorari petition to the U.S. Supreme Court, time to submit a successive federal habeas corpus petition, and then he denied a request for attorney time and paralegal time for an original habeas corpus petition at the U.S. Supreme Court, denying that request in its entirety is not reasonably necessary in light of the probability that such a writ would not be granted if other efforts raising the same issues before the Oklahoma Court of Criminal Appeals and federal court have failed. He also found that Glossop's request for legal counsel to challenge the death watch procedures was denied, finding that the proposed actions were a new variation on the same theme, given the failure of prior execution protocol challenges made by Glossop et al. And that was not reasonably necessary. So he approved a budget of $47,718 for all clemency and subsequent proceedings on behalf of Glossop. Again, there's another one-sided narrative in the Intercept portraying the state's case as refuted and ignoring the countless prior legal opinions that refute their opinions regarding Glossop's alleged innocence. Glossop's clemency hearing was postponed by the Oklahoma Pardon and Parole Board. There's a new date that will be set, but it has not been set yet. On January 3rd, 2023, Glossop's counsel did file a petition for a writ of certiorari challenging the Oklahoma Court of Criminal Appeals denial of his second state post-conviction writ. While he mixed in some of the claims raised in the first successive writ filed in 2022, that doesn't appear to be one of the items he's seeking. They've also filed an application for an extension of time to file a writ with the U.S. Supreme Court on the failed lethal injection challenge. And that has been granted with a date due of March 18th, 2023. However, that's an extraordinary writ. And so if Glossip wants to get a stay of execution, he's going to have to seek a stay of execution with the Supreme Court pending the outcome of that writ or at the outcome of that petition. And the state has already filed its brief in opposition to his state court writ denial challenge, and basically arguing that the Supreme Court does not have jurisdiction over claims that were procedurally defaulted by adequate and independent state law grounds. So that remains to be seen. Glossip's execution date is scheduled for February 16th, 2023. He has not gone to death watch, which he should have gone to death watch on, I believe it would have been the 11th. At least by the 12th or 13th, because Scott Eisenberg was on death watch prior to that date, but he was executed on the 12th. So we'll have to wait and see. And all right, we talked about James Coddington's execution. Nothing new has come up. He was executed on August 25th. Not surprisingly, because it was all about him, he didn't even mention his victim, Albert Troy Hale, who was murdered on March 5th, 1997 by Coddington, his friend, at the age of 73.
You would think at some point you would just say, hey, I'm sorry, I apologize. Like, you would think on death's door, you would just apologize and say.
Coddington was a hell of a guy because he forgave Kevin Stitt for not granting him commutation.
Exactly. Yeah, exactly.
And his execution was carried out without complications. And then Benjamin Cole, his attorneys did challenge his competency to be executed in the lead up to his execution date in October of 2022. They had a county court find that their request for mandamus relief was denied. The court found that Cole was competent to be executed after hearing, and based on expert reports submitted by the parties, including an agreed evaluation between the state and Cole by a Dr. Orth. That was also denied by the Court of Criminal Appeals, which denied the writ of mandamus as well as a motion for stay of execution based on the Pittsburgh County findings of Cole's competence to be executed. Cole filed a supplemental petition with the U.S. District Court in the Northern District of Oklahoma, where he had prior competency proceedings, pursued prior competency proceedings, and sought a stay of execution. That was opposed by the state. And these were filed on October 18th and October 19th, 2022. The court issued its opinion on October 19th, 2022, denying Cole's request for an evidentiary hearing, denying the petition for writ of habeas corpus, denying the supplemental petition, alleging Cole was incompetent, denying a certificate of appealability, denying the stay of execution, and entering a judgment on that order. That was appealed to the U.S. Supreme Court with an application for stay of execution and an independent writ. Those were denied on October 19th. And a second original writ of habeas corpus and stay of execution were filed, but they were denied on the 20th of October. Cole was executed on October 20th. The administration of drugs began at 10:06. He was declared unconscious at 10:12, and he was pronounced deceased at 10:22.
Cole was a strange cat. I mean, both his crime, and even
He-
after that, he is a strange
He
bird.
was, and there was actually kind of an interesting statement made by the Court of Criminal Appeals, which reminded me of one of my statements when you and I talked about the case.
Yeah.
It said Cole, while exhibiting peculiar behaviors, completely and rationally understood the proceedings, what he
Right.
was tried for, and that his execution was imminent.
He was pretending to be. He's kind of like Damien Echols. He was pretending to be off, but
Well, I think it was more than that. I think that he was insulted by his counsel's attempts to portray him as crazy because of his religious beliefs. And so he decided, fine, you want to make me crazy? I'm not going to talk to you. And also in his interview with Dr. Orth, Cole told him he was sentenced to death for killing his daughter and that he accepted responsibility for that. He also knew he was third on the list and believed his execution date was 10/20/2022. Contrary to the attorney's claims, people at the prison never observed him to be dirty. They also found that he was specific about ordering items from the canteen and voicing complaints if the orders were not correct. They also found that he requested additional items for his cell when he was transferred to Death Watch on September 15th, 2022 to stay warm.
Right. Yep.
Basically, Cole decides if he will speak, consciously decides if he will speak to people or he won't.
Right.
And that reminded me that while exhibiting peculiar behaviors, that's like sticking a toilet seat on your head and wanting everybody to call you King Johnny.
Yeah, exactly.
So he was executed without complication. He did give a final statement, but it was kind of a rambling statement that none of the reporters sought to put down, but it reflected his religious belief and encouraged witnesses to get right with God.
Right.
Or Jesus. Richard Fairchild, his victim was 3-year-old Adam Scott Broomhall, who was murdered on November 14th, 1993. His counsel also filed a motion alleging mental incompetence, which was denied by the OCCA on November 17th. They filed this like on November 15th. They initially sought, they tried to take advantage of a prior procedure which had been repealed, and a new procedure had gone into effect on November 1st, 2022. So they kind of wasted time trying to use that prior procedure to have Fairchild, their allegations about Fairchild's competence examined. They didn't file a proceeding in the court to pursue competency proceedings. They certainly didn't do it when they should have. They waited until the last minute, and that was denied basically because the evidence that they submitted demonstrated that they had doubts about Fairchild's competence before November 14th that could have been raised at the time they began to have doubts, and that should have been raised at the time they began to have doubts. They also found that the evidence was insufficient to meet the substantial threshold requirement to show a substantial deterioration of Fairchild's condition to the point of incompetence.
But
now, and one thing I want to mention is one of the things they did is they didn't have Fairchild appear at his competency hearing because they claimed he didn't know why he was being executed. And he had told them he was being executed because his brother was selling drugs in prison and was having him killed to take control of money. So, I mean, they had some pretty wild allegations going, but their motion was denied. Their application for stay of execution was denied. And They filed an application at U.S. Supreme Court, which was also denied on November 17th. Now, Fairchild's execution went forward on November 17th, and contrary to his attorney's claims, Fairchild final words refuted their
Yeah,
claims.
that's what I was gonna say. Like, I have to, give him credit because he actually expressed remorse and apologized and seemed to be, I did it. I'm sorry. I'm genuinely remorseful. And so, credit to him for owning his actions.
Yeah. And he said today is a day for Adam, justice for Adam.
Exactly. Yep. I mean, he clearly knew what he did and had genuine remorse. So I think his soul will find peace in the afterlife.
And it's kind of interesting because he didn't appear at the clemency hearing. If he had appeared at the clemency hearing and made this statement, they might have granted a commutation.
But I feel like he might have been somebody who was genuinely remorseful and felt like, you know what? I need to pay for my crime, and my soul will be better to pay for my crime.
I think that the attorney's decision was a strategic one. They wanted him to appear incompetent, so they said he can't even come to the clemency hearing because that's what they claimed. And so that was to bolster their claims of incompetence to be executed. But again, it didn't work. And he was executed without complications. The drugs were administered at 10:10, and he was pronounced deceased at 10:24. And then finally, John Hanson, the federal court action challenging the denial of his transfer by the federal authorities was dismissed for lack of jurisdiction, because the habeas corpus is properly before the Western District of Louisiana, where Hanson is incarcerated. Then the court ultimately did find that it lacked authority to review the Bureau of Prisons decision. They denied the preliminary injunction and again dismissed the case for want of jurisdiction, stating that Congress had limited the court's ability to engage in a debate about public interest. On December 13th, the date of this order, John O'Connor, the Oklahoma Attorney General at that time, said he disagreed with the court's decision, that it is in the public interest for John Hanson to face justice for the murder of Mary Bowles, and that he was evaluating their options going forward. And again, I skipped over in this case, the murders of Gerald Max Thurman, who was 45, and Mary Agnes Bowles, who was 77, occurred on August 31st, 1999, and were committed by Victor Miller and John Fitzgerald Hanson, also known as George John Hanson. George Hanson, he's serving a life sentence in a federal prison for bank robbery committed during this crime spree that had begun with the murders. So that is basically the options now are an appeal to the Fifth Circuit or to try in the Western District of Louisiana to have this decision reviewed. And I think it sets a bad precedent that the federal government is going to end up regretting, because the next time Oklahoma has a federal bank robber in custody, they probably are not going to transfer that bank robber to federal custody to be tried and just keep him in state, especially if he's on death row.
Yeah, no, absolutely. Why would you just get him released?
And I think on Skinner, which was the last case we talked about, I think I'm going to actually just skip over that. Of course, the murders occurred on December 31st, 1993. The victims were Twyla Busby, 39, Randy Busby, 20, and Scooter Kaler, 22. In Pampa, Texas, Gray County. We did talk about Skinner's motion state DNA testing challenge. Well, okay, let's see. Rewind. Skinner had challenged the denial of relief by the trial court of a new trial based on DNA results from testing performed from 2012 to 16 or 17. The Court of Criminal Appeals affirmed denial of relief, and Skinner had filed a motion for rehearing in October. On January 11th, 2023, that motion for rehearing was denied. So the mandate has issued on Skinner's claim. I am betting that his attorneys will now go to the U.S. Supreme Court and challenge that. And I'm sure they're cooking up other challenges. Skinner does have a September 2023 execution date on the books. So we'll have to see how that's going to play out. Right, Kyle?
Yep. Hopefully just justice continues and we don't have to get more courts clogged with just stupid motions from the obviously guilty.
Yeah. So, all right. Well, that is the update on what has happened, what we looked at in season 1. We will, of course, update again as events occur. I may start as a regular feature of just anything that has changed in the last 2 weeks.
Yeah, it would be good to stay updated on all these cases, just to kind of stay current on them.
And maybe like in the middle of the season with season 2, in the middle of the season, we'll go ahead and anything that's had new events and new developments we'll talk about.
Right.
But we won't have to talk about everything that we've talked about if there's nothing else new in a case. And looking at cases in the future, of course, I am going to be interested in talking about State of Texas versus Robert Allen Fratta and State of Texas versus Joseph Prytash and Howard Guidry. That is a murder for hire case out of Houston, Harris County. Robert Fratta was recently executed by the state of Texas after 26 years on death row and 2 trials. So that will be an interesting case. Prytash was the middleman. Howard Guidry was the shooter. And so we're going to look at Fratta's case and then Prytash and Guidry, because they are all 3 very complicated. Another one is Oklahoma versus Scott Eisenberg, who was also recently executed. Then we've got State of Arizona versus Jodi Arias. I looked at her case prior to her direct appeal, and now her direct appeal has been decided, and I think her state post-conviction has been decided as well. State of New Jersey versus Melanie McGuire. That's a case that I looked at on Clear and Convincing, but there have been some new developments. And it's an interesting case. It's a wife who murdered her husband, put his body cut his body up and put it in suitcases and dumped him in the Chesapeake Bay. And then tried to tell people that he took off to New Jersey, to Atlantic City, and was captured on video apparently moving his vehicle, or was documented on a cab fare going to Atlantic City or coming back from Atlantic City. Didn't cover her tracks real well. State of Florida versus Dahlia DiPolito, which is another murder for hire case. Linda Anita Carty, State of Texas. I think we'll look at Routier too. State of California versus Scott Lee Peterson. State of Louisiana versus Robert Jones. Maryland versus Adnan Syed. Ohio versus Elwood Jones. And hopefully our friend Rob Chadwick, or my friend from Twitter, Rob Chadwick, can come join us for that episode. State of Missouri versus Charles Erickson. And probably Ryan Ferguson. State of Texas versus Charles Victor Thompson. State of Florida versus James Daly. And I want to look at some innocence fraud cases. Al Story Simon, Ryan Ferguson, Stephen Avery, because I'm sure there's going to be another loss for Kathleen Zellner to talk about.
Is that case still going on? I mean, I thought that was settled.
She filed another.
Is she just clogging the courts with more crap?
Yeah. She files another successive hundreds of pages. Because I
honestly, I didn't even think anybody doubted his guilt anymore. Like, I thought even the most ardent innocence fraud supporters had finally realized that.
Well, I think the thing is that they parse testimony and they parse statements, and then they call everybody is a liar, and Brady violations and Brady violations and Brady violations, and they find a piece of paper that's ambiguous and they turn it into something it never was.
Right.
And sometimes they're able to fool the courts, and sometimes they get a defense-oriented prosecutor or a progressive prosecutor who wants to open the jails and let everybody free anyway, to let someone go, like Adnan Syed.
I wish they would do that though, and just do like they do with some of the other issues and just move them all to San Francisco. Like, let's release all the convicted murderers and just put them on a bus to Rodeo Drive or to San Francisco and let them live there.
Oh, I don't think they'll do that. I don't know. I mean, San Francisco, it's already bad enough with the homeless, and it's.
I'm just saying, if you want to be all like, no one ever committed a murder, it was all framed, fine. Just you live with that opinion.
Yeah.
All the people you want freed, great. Let them live in your neighborhood.
Yeah. So what are cases you want to look at?
I think you hit the big ones. I mean, the one that's, just curious because it's gotten so much public opinion is the Idaho one. But like you said, until something actually happens in the court system, there's not much to look at.
Yeah. And that one, I would prefer to wait until Kohlberger has gone to trial.
Yeah.
And if he's convicted and sentenced, that his case is reviewed on direct appeal.
I'm just really confused by, like everybody else, why it's come out in the police reports that the one roommate saw him, but then didn't call the police for a while. Something's very suspicious. There's something in this case that doesn't make sense.
Well, but I would say, I would look at it this way. You don't know how you're going to react. Is that roommate male or female?
I think it was female, right?
Okay. So, and I haven't read the accounts or anything about it. I've seen that she saw somebody and then she didn't call police for, what was it, 17 hours or something?
It was something like that. Like, I think that she saw him.
But did she go out and about and do her thing? Or did she see him and hide during that time? What are the details? And in the articles I've seen, there are very few details. I mean, it could have
Yeah,
been,
I just-
is she the one who found the bodies?
well, I mean, I mean, I guess where I go is like, I can see that if you witness the murders, why you might have some, shock. But according to her report, she didn't witness anything. She just saw a strange guy walking down the hall in a mask with bushy eyebrows, which to me doesn't trigger any kind of, PTSD. It's like, okay,
But
you see a
yeah, but
strange
see,
guy walking down
again,
the hall. You're like, okay,
a
well,
strange guy in a mask walking down the hall, but did she go back in her room and hide in her closet
I
until
mean,
police came
well, yeah,
to
but
do a
why wouldn't she
welfare
call the
check?
police though? I mean, yeah, it's like, why wouldn't you call the police?
But
That's what I don't
she
get.
saw him in the hall. Maybe she went back in her room before he saw her, and she didn't know whether he was still in the house or not. Did she have a cell phone at hand, or was she in the bathroom without her cell phone? The person who can answer those questions is that witness, that
Yeah,
lady,
yeah,
that
and it'll
young
make it
lady.
interesting to see what she says.
And I mean, I just watched on HBO Max over the weekend because I love Jenna Ortega from Wednesday. She is just a phenomenal actress for such a young woman. And I watched a movie called The Fallout. And it's about a school shooting. And I mean, basically, she's in the bathroom with another girl. They hear gunfire. They go into a stall. They climb up on the toilet seat and they just cower there, listening to the gunshots, covering their mouths, hoping the kid doesn't come in after them. And then when it's all clear, when the police get there and they hear the police and I think they hear the police take out the shooter, that's when they finally, they come out. So I'm saying maybe she saw somebody in a mask in the hall, went back and hid because he didn't see her yet, and then stayed sheltered in place and didn't have access to a phone to call police, or was afraid to call police because she's afraid he'd hear her and come find her. Because a guy in your apartment in a mask is not bringing you cookies and puppies in the middle of the night, because I'm presuming this was the middle of the night. Correct?
Yeah, I mean, that's the report. I don't know.
So,
I
mean, I'm sure, and another thing is there's a reporter that probably has her full statement and her full explanation of why she did what she did or didn't do what she didn't do.
What's weird though is then when she calls the next day and is like, oh, here's a scene where there's been 2 victims stabbed to death. Oh, they're just might be unconscious. Like there's no blood anywhere. There's something suspicious about this. That and his always question, did you talk to the other suspect? Something, I don't know. There's something weird about this. I mean, I just don't
Okay.
know how there's 4 people stabbed to death and the person who finds the bodies doesn't notice any blood and just like, oh, look, there's somebody passed out.
I don't know. Again, perception is a funny thing. And I think this is what the innocence fraud movement does. They claim witnesses couldn't have seen what they saw, or they claim they should have seen things they didn't see. And that's kind of, you're speculating on what you think she should have seen based on the facts, but we don't have crime scene pictures.
No,
How bloody was the scene?
That's
Were
totally
the victims
fair.
covered?
No, you're totally right. That is fair. We have not seen crime scene photos. They're
and
totally fair.
I did see a video of a noise complaint at the house prior to the murders. So I'm guessing that there was probably some partying going on at the house, which would then lead
Yeah.
me to think that perhaps seeing somebody in a mask in the middle of the night wasn't that strange. It wasn't like a 10 on the scale. It was
Yeah.
maybe a 4
And see,
to
that would
not
be
even
more
worry
believable to
about.
me. She was like, oh yeah, some
And
random dude walking down the hall.
and
No,
you
no
you've
big deal.
you know, you've got to recognize the fact that
All right.
sometimes we see things and we don't realize their importance until we learn additional facts. Like,
No, I
um,
gotcha.
she's leaving for work and she sees a strange guy in the backyard, but she thinks it could be somebody looking at a water meter. And so she drives away and she goes to work and she doesn't call police. I saw a stranger in the backyard.
Yeah.
And then she comes home and she finds everybody dead. Then the stranger in the backyard takes on a significance that he didn't have when she first saw him in the morning. You see?
Yeah.
So
I get you. That makes sense.
if she saw a man, and again, if she heard noise and she saw a man in the hall, her reaction may have been to go shelter in place and hide for her own safety and to preserve her own life. And we don't know because we don't have the report or we don't have her full statement, which a reporter probably has, that details exactly what happened. Because
Right.
I can promise you, the delay between her call and report of this, man was looked at by police. And sometimes I think the media and reporters do that. They want to break something later. So they
Yeah.
give the appearance of a mystery.
Yeah. They want to create something strange where there's nothing there. Yeah, I get you. That makes sense.
So, I mean, I could think of reasons that she may have not called. Again, she found 2 people, but she didn't find the other 2. They were found later. Another case I want to look at maybe is Missouri versus Pam Hupp, but
Yeah, that's crazy.
she is still awaiting trial. Or I think she entered out for plea, but she hasn't been sentenced.
Yeah, that's what. Yeah, she finally. Yeah,
So, but I want to look at that one too. And
that's the one with the Renee Zellweger TV show,
yes,
right?
and that is a Russ Faria. That is a case, clear-cut case of wrongful conviction.
Yep.
And it's a clear-cut case of the DA doing and some police officers doing everything that they're routinely accused of doing in these other cases that they didn't do, but doing it in the Faria case and in their prosecution of Russ Faria.
Right.
And I was wanting to maybe interview the attorney who represented Russ Faria, but I don't know that that's going to happen, because while he wants to appear on TV and he wrote a book, podcasts just don't sound like his thing.
Right. Yeah. He's got the.
So
Yeah, you got to have a certain amount of money to get him to come on.
Yeah. But I mean, any other cases that old cases, recent cases?
None of them, I mean, unfortunately, none of them that have been that have been gone through appeal. I mean, the biggest ones, I think I talked with you last time, the one, most of the ones that really interest me are the ones that have remained unsolved. Which was just so interesting. So I think that's where it's tough, because it's the ones that really fascinate me are the ones that have gone unsolved, that we just have no idea. People just disappear out of thin air, or just, you find their body and there's no idea who did it.
Yeah. And that, I mean, I'm interested in those, but the problem with those is that I can't criticize people like Bob Ruff, who, quote, investigate, unquote.
Well, and it's hard because, I mean, I have fairness. I totally get it. You're just looking at speculation. You're like, well, here's a great theory. Maybe Barack Obama came down and kidnapped this person. I mean, well, why not? It's as good as anything else. I mean, there's no reason to believe, there's no reason to either say that's right or wrong. There's nothing to really sort of evaluate,
Yeah.
which is totally
Yeah.
fair, unless you're going to spend, $100,000 and really do a totally new investigation.
Mm-hmm. And I would want, if I was going to do something like that, I would want direct access to police reports and
Right.
records and all those things that I'm not entitled to
Right.
because I'm not an investigator and
Yeah, that's
it's
exactly
an
right.
open
Yeah.
case.
Yeah, and
know.
you're just making up theories and throwing stuff against
Yeah.
the wall. And yeah, if some people think it's interesting, it'll stick, but otherwise, it's like there's no way, you can't really evaluate it fairly.
Mm-hmm. Yeah. But in that vein, I think we could look at some cases that could have gone unsolved. John List, for example. He murdered his family in New Jersey.
Yeah, that
walked away, started a new life, and was caught because of America's Most Wanted. And was convicted even after the years that had passed, and died in prison. And we've seen some like the KFC murders. I mean, that could have gone unsolved, but DNA solved it. Stacy Stites could have gone unsolved, but DNA solved it. So, we have some others that, yeah, but we could look at some that almost went unsolved, but through divine intervention, a suspect
the
was identified.
The DNA is amazing. I mean, I just don't. I mean, it's back to the Idaho thing. I mean, the guy is a criminal justice major. I don't know how anybody that studies crimes would ever want to commit one, knowing just how, you just sweat and they can get your DNA. I mean, it's virtually impossible.
Well, he also,
to pull off the perfect crime.
He probably took some forensic countermeasures, but there's always inadvertence. And I think this one was a knife sheath and a knife were left behind, and the knife sheath had his DNA.
Yep.
Which he probably didn't intend to do. And I'm going to say this. I mean, even though a lot of criminals are stupid, they think they're smart.
Yeah. I mean, because, I live in no secret, I live in the Dallas area, and there was a case here that was 40 years old that was recently solved, much like the original Night Stalker case, where they found DNA, tracked the guy down, went to his garbage and finally found DNA to match just a little bit of a tiny little DNA patch on her dress from 40 years ago and convicted him.
Was that the guy taking the eyes? Because I think that was in Dallas. There was a guy.
No. Okay. That guy was caught a long time ago. This was in the Carla Walker murders in Fort Worth. I forget the guy's name, but it's funny enough, his name actually sounded kind of like the original Night Stalker guy.
Ramirez?
Yeah, Glenn McCurley was the guy here.
Okay.
Who sounded like the D'Angelo or whatever, and the original I saw. He was the D'Angelo in California.
Wait, no. You're thinking of the Hillside Strangler, Angelo Buono and Kenneth Bianchi. Richard Ramirez was the Night Stalker.
Oh yeah, no, I'm thinking of the original Night Stalker though, the East Area Rapist original Night Stalker.
Oh, okay, yeah. Yeah, he was. No, he wasn't Night Stalker. He was Golden State Killer. I think they thought some of his murders were Night Stalker, but I think they ended up ruling those out because Ramirez was in the Los Angeles area, and
Yeah.
this guy was in Central and Bay Area.
Yeah, it's amazing how the DNA just, all these years later. And what's crazy about this guy, he still lived maybe, maybe less than 5 miles from the murder scene. Like he'd never moved after all these years, which I'm like, I would have gotten out of town, but no, he was arrested, I think less than 5 miles from the scene of the murder. It lived there his whole life.
Wow. Well, yeah, some of them are creatures of habit too.
Yeah, and that's the thing. People speculate that he probably killed other people, but he's never been connected to anything but this one murder.
Yeah. And that was from Tarrant County.
Oh, did I lose you?
No, I'm still here. I was just thinking. All right. Well, I think that that will wrap us up because I think our Zoom time's about to expire. I don't remember how long I set it for. All right. You ready? Okay, we're ready to go. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans. If you like the show and want to know more, you can find us on Facebook or follow me on Twitter at O'BrienLN. Join us in 2 weeks for episode 2, State of Texas versus Robert Allen Fratta. In part 1, we'll look at the case against Fratta, who was executed on January 10th, 2023 for the 1994 murder for hire of his estranged wife, Farah Bacher Fratta. We'll look at the evidence against Fratta and his initial conviction, as well as his 2009 retrial, direct appeals, and state and federal post-conviction claims. Finally, we'll talk about the last-minute claims made in an unsuccessful effort to stop his execution. Until then, have a great 2 weeks and stay safe. Good night.